A pleasant day, everyone. I am Adriana Fernandez from TCPT 3 and today I'll be presenting an article analysis of Republic Act number 4200. In relation to Republic Act 4200, an act to prohibit and penalize wiretapping and other related violations of private communication and other purposes. And here I will answer the following question below. First, topic 1, wiretapping or ambush interview. What is the article all about and how does it relate to the anti-wiretapping law? Topic 2, video and audio recording on mobile phones. Also, what is the article all about and how does it relate to the anti-wiretapping law? Now, let's dive into topic 1, wiretapping or ambush interview. In this article, there are 3 main cases delves into the intersection of wiretapping laws and ambush interviews, particularly focusing on how these practices are viewed under the legal framework of Republic Act 4200. So, the first case was Ombudsman declares wiretapping by PCIJ mount on Duterte Sal and released. So, this case is about Ombudsman Samuel Martirez accused PCIJ Executive Director Malumang Ahas of illegally recording a conversation without his consent, which was later quoted in a PCIJ report on President Duterte's unreleased 2018 SALN. Martirez claimed this violated the wiretapping law, but PCIJ countered that the conversation was held in a public place and on a matter of public interest, and it was also recorded with Martirez and his staff's awareness. So, what does it relate to the anti-wiretapping law? But first, let's talk about what does the law says. So, the article also provides information about this law. So, Republic Act number 4200, the anti-wiretapping law signed in 1965 that protects the right to privacy of communication. Violation occurs if recording is done without all parties' consent, using devices to secretly overhear, intercept, or record private communications. Liability extends to those who knowingly possess, replay, or communicate wiretapped recordings and assist in wiretapping. This law also covers recordings regardless of where they were made. In 2018, it expanded to include public telecommunication entities. Wiretapping is all allowed for serious crimes like treason, espionage, sedition, rebellion, and kidnapping, with written court orders required. So now let's proceed to answer what does this case relates to the anti-wiretapping law. So the point of Martirez accusation depends on whether the conversation was private and if consent was given, while PCIJ maintains it was public conversation recorded, transparent. Moving on to our next case. This case is about Justice Secretary Vitaliano Aguirre II filed a complaint against Senator Risa Ontiveros, accusing her of violating the anti-wiretapping law by showing a photo of a text message exchange between him and certain Kong Jin. So, during a Senate hearing, Hontiveros claimed that the photo was inadvertently captured or accidentally captured during the hearing, while Aguirre alleged it was secret recording without consent. So, in relation to anti-wiretapping law, Aguirre's complaint hinges on whether the text message exchange was private and if Hontiveros recorded it without authorization or consent. Hontiveros argued that the conversation took place in a public setting and was matter of public interest. For our last case, People versus Cecilia or Cheche, also known as Cheche Nazaro. This case is all about broadcast journalist Cecilia, or Cheche Nazaro, was charged in 2010 with allegedly wiretapping a conversation with Ella Valenciarina, an official of the Government Service Insurance System, or also known as GSIS, without consent. So Lazaro recorded part of their conversation and aired it in a segment. However, she was accused that due to the lack of evidence, as Valenciarina admitted in court that she was fully aware of the recording. So, in relation in anti-wiretapping law, in this case, in Nazaro's case, the court ruled that since Valenciarina was fully aware of the recording, it did not constitute as wiretapping. The act was seen as a journalist recording a conversation with consent, which is not punishable under the law. Next, into topic 2, video and audio recordings on or in mobile phone. In this article, there are also 3 main cases that we will examine how mobile technology has made an incredibly easy for anyone to record conversation and events with exceptional clarity. And however, we also consider the legal consequences of such recordings. So for our first case, we have here the Salcedo versus Court of Appeals, like I mentioned earlier. And so this case is all about the Supreme Court in Salcedo Ortanes versus Court of Appeals. Their 1994 ruled that a recording is illegal under Republic Act number 4200 unless there is clear evidence that both parties are being consented. So, for recordings made with mobile phones, and the recorded conversation itself should provide the best evidence of mutual consent. So, in relation to our anti-wiretapping law, the ruling aligns with the anti-wiretapping law by emphasizing the need for clear consent for all the parties involved in a recorded conversation. So next, we are Ramirez versus Court of Appeals. And the case is all about the Supreme Court ruled that unauthorized recordings are illegal regardless of who makes them or where they are made, publicly or privately. So, Republic Act number 4200 aims to penalize any unauthorized recording, whether the conversation occurs in private or public spaces. So, in relation anti-wiretapping law, any unauthorized recording, regardless of who makes it or where it's made, is illegal. The law aims to protect private communications by penalizing anyone who record conversation without clear consent of all parties involved. So lastly, we have or the title was repeated, but this is about Mamba versus Garcia, as well as the Office of the Court Administrator versus Floro. Involved the Supreme Court ruling that recordings made without the consent of all parties, even within a judge's chamber or classified as a public place, are illegal. These cases highlight that any conversation recorded without clear consent from all involved parties is prohibited. In relation to anti-wiretapping law, this ruling affirms the intent of anti-wiretapping law to prohibit unauthorized recordings by classifying judges' chambers as a public place. The court emphasized that location does not alter the illegality of unconsented recordings, reinforcing the law's strict stance on protecting communication privacy. And for our summarization, or for the summary of those two topics or articles we tackled, for the topic 1, wiretapping or ambush interview, this article examines 3 key examples of potential violations of the anti-wiretapping law, wherein individuals, PCIJ, Senator Rizal Tiveros, and journalist Chechen Nazar were accused of illegal recording. In each case, the main issues are whether it was consent or it's consented was obtained for the recordings, and whether the conversation was held private or public. The law's implementation depends on these facts to decide whether wiretapping happened. For our topic, video and audio recording on mobile phones, this article focuses on cases where unauthorized recordings were publicly or privately held, like in topic 1, become illegal under the anti-wiretapping law. The courts highlighted the importance of obtaining express authorization from all parties before recording, regardless of the location or approach, highlighting the law's protection of communication privacy. So that's all for today. Thank you for watching.